Imagine this. You are sitting in a courtroom. The lights are harsh, the air is cold. A judge is staring at you. A prosecutor stands up and points directly at you and says, "This person committed the crime. We have witnesses. We have forensic reports. We have everything we need to prove it." The entire room goes silent. Everyone looks at you. And in that single terrifying moment, the only thing standing between you and a prison cell is evidence. Not just the prosecution's evidence, but your evidence. The evidence your defense team presents to prove your innocence, to challenge the government's case, to create doubt in the minds of the jury, and to fight for your freedom. Today, we are going to go deep, very deep, into one of the most important, most misunderstood, and most powerful concepts in the entire criminal justice system. We are talking about defense evidence in criminal cases. So take a breath, stay with me, and let's break this down completely, step by step, word by word, example by example, because this knowledge could one day change everything for you or someone you love. Before we go any further, let's establish one fundamental truth that sits at the very foundation of every criminal justice system in the democratic world. And that truth is this: a person accused of a crime is presumed innocent until proven guilty. Say that again slowly. Presumed innocent until proven guilty. This means the burden of proof, the responsibility of proving that a crime happened and that you did it, rests entirely on the shoulders of the prosecution, which is the government or the state. The defense, meaning the accused person and their lawyer, does not technically have to prove anything. But here is where it gets interesting, and here is where defense evidence becomes absolutely critical. Just because the defense doesn't have to prove innocence doesn't mean they should stay silent. In fact, the smartest, most effective defense strategies in history have involved presenting powerful, well-organized, strategically chosen evidence to dismantle the prosecution's case piece by piece. And that is exactly what we are exploring today: what defense evidence is, the different types of defense evidence, how it works in a real courtroom, and why it matters so deeply to justice itself. Let's start from the very beginning. Defense evidence is any piece of information, testimony, document, object, scientific finding, or recorded material that is presented by the defense team in a criminal trial to support the innocence of the accused, to challenge the reliability or accuracy of the prosecution's evidence, or to establish a legal defense that reduces or eliminates criminal responsibility. Think of a criminal trial as a scale, a balance. On one side, you have the prosecution placing their evidence, their witnesses, their forensic reports, their CCTV footage, their expert testimonies. On the other side, the defense has the right to place their own evidence to balance that scale, or better yet, to tip it in their favor. Now here's a simple, clear example to make this real. Suppose a man named David is accused of robbing a convenience store on the night of March 15th at 9 p.m. The prosecution presents a grainy CCTV image showing a man of similar build wearing a dark jacket entering the store. They also present a witness who says she saw someone matching David's description running away. That sounds serious, right? That sounds like a conviction waiting to happen. But then David's defense lawyer stands up and presents a receipt from a restaurant 40 miles away, showing David paid for dinner at 8:55 p.m. that same night. They present the restaurant's own CCTV footage showing David sitting at a table, laughing, eating, completely unaware that a crime was being committed somewhere else entirely. They call 3 witnesses, David's friends who were at dinner with him. Suddenly, the prosecution's case doesn't look so strong anymore. That restaurant receipt, that footage, those witnesses, that is defense evidence, and it just saved an innocent man's life. Now let's go through the major types of defense evidence, because each type works differently, serves a different purpose, and carries a different weight in the courtroom. The first and perhaps most familiar is witness testimony. A defense witness is someone who takes the oath, sits in the witness box, and speaks on behalf of the accused. This could be a character witness, someone who knows the accused personally and testifies about their good moral character, their honesty, their nonviolent nature. For example, if someone is charged with assault and their pastor, their employer, and their neighbor all testify that in 20 years of knowing this person, they have never seen a single act of violence, that testimony plants a seed of doubt in the jury's mind. But witness testimony can also be direct, someone who actually saw what happened, or more importantly, who saw what did not happen. Going back to our David example, his dinner companions are direct witnesses, placing him at a specific location at a specific time, which in legal language is called an alibi, and we'll talk about that very soon. The second major type is documentary evidence. This includes any written or recorded material: receipts, emails, text messages, letters, medical records, bank statements, contracts, photographs, videos, and audio recordings. Documentary evidence is powerful because it's often objective. A bank statement showing that the accused was making ATM withdrawals in a city 300 miles from the crime scene at the exact time the crime occurred is not a matter of opinion, it's a fact recorded by a machine. Courts take documentary evidence very seriously because it's harder to fabricate and easier to verify. The third type is physical or real evidence. This refers to tangible objects, things you can physically touch, examine, and present to the jury. For the prosecution, this might be a murder weapon found in the accused's home, but for the defense, physical evidence could be equally powerful. Imagine a case where someone is accused of breaking into a house, and the prosecution claims they used a crowbar. The defense presents evidence that the lock on the door was broken from the inside, meaning someone staged the break-in. That door, that lock, that crowbar, or the absence thereof, becomes critical physical defense evidence. The fourth type is expert evidence, and this is where modern criminal defense has truly evolved into a science. Expert witnesses are professionals with specialized knowledge: forensic scientists, medical doctors, psychologists, ballistics experts, digital forensics analysts, DNA specialists, and more. These experts don't just testify about what they saw, they testify about what the evidence means. Consider a case where the prosecution's forensic expert claims that DNA found at the crime scene belongs to the accused. The defense can call their own forensic DNA expert, who examines the same sample and testifies that the sample was contaminated, that the laboratory procedures were flawed, that the chain of custody was broken, and therefore the DNA evidence is unreliable. That expert testimony can completely destroy what seemed like the most damning piece of prosecution evidence. We saw this play out famously in the O.J. Simpson trial, where the defense team's experts successfully challenged the integrity of DNA and blood evidence collected by law enforcement, introducing enough doubt to influence the jury's verdict. The fifth type is alibi evidence, which we touched on earlier but deserves its own spotlight. An alibi is a defense that asserts the accused was somewhere else when the crime was committed, and therefore could not have committed it. Alibi evidence can include everything we've already discussed: witness testimony, receipts, telephone records showing cell tower location, hotel check-in records, flight boarding passes, social media check-ins, GPS data from a vehicle or smartphone. In today's digital age, establishing an alibi has become easier and more complex. Easier because digital footprints are everywhere, and more complex because those digital footprints must be properly authenticated and explained to the jury. Beyond just challenging the prosecution's case, defense evidence is also used to establish specific legal defenses, recognized legal arguments that, if proven, can reduce or completely eliminate criminal responsibility. The most well-known is self-defense. If someone is charged with assault or even murder, and they claim they acted to protect themselves or others from imminent harm, their defense team must present evidence supporting that claim. This might include photographs of injuries the accused sustained, medical records, witness testimony from people who saw the aggressor acting threatening, text messages showing prior threats made by the victim, and sometimes expert testimony from a use of force expert who explains why a reasonable person in the same situation would have felt their life was in danger. Another powerful legal defense is the insanity defense, also called the mental disorder defense in many jurisdictions. This defense argues that at the time of the crime, the accused did not understand the nature of their actions or did not understand that what they were doing was wrong because of a severe mental illness. Evidence for this defense typically includes psychiatric evaluations, medical records documenting the history of mental illness, testimony from mental health professionals, and sometimes testimony from family members who witnessed the accused's deteriorating mental state. Then there is duress, the argument that the accused committed the crime because they were forced to by threats of serious harm or death. Evidence here might include communications showing the threats received, testimony from witnesses who can corroborate the accused's fear, and records showing the accused had no realistic means of escape from the threatening situation. Understanding the types of defense evidence is one thing. Understanding how it actually enters the courtroom is another. The process is formal, rule-governed, and strategic. After the prosecution presents their case, the defense has the opportunity to cross-examine every prosecution witness, meaning they can ask probing, challenging questions designed to expose inconsistencies, biases, or errors in that witness's testimony. This cross-examination is itself a form of defense, using the prosecution's own witnesses to weaken the prosecution's own case. Then the defense presents their case. They call their own witnesses, who are first questioned by the defense lawyer in what is called direct examination, and then cross-examined by the prosecutor. They submit their documents and physical evidence for the court's review. They present their expert witnesses. Every piece of evidence must be relevant, meaning it must actually relate to the facts in question. Every piece of evidence must be admissible, meaning it must have been obtained legally and must meet the standards set by the rules of evidence. And crucially, the defense must often establish the foundation of their evidence, proving to the judge that the evidence is what they claim it is before the jury is even allowed to see it or hear it. Here is the deeper truth that we must never lose sight of. Defense evidence is not just a legal technicality, it is the beating heart of justice itself. History is full of people who were convicted without adequate defense evidence and who spent years, sometimes decades, in prison for crimes they did not commit. The Innocence Project, an organization dedicated to exonerating wrongfully convicted individuals through DNA evidence, has helped free over 375 people in the United States alone as of recent years. People who were convicted, some even sentenced to death, because the defense evidence that could have saved them was either unavailable, ignored, suppressed, or inadequately presented. Every time a defense lawyer stands up in court and presents a receipt, calls a witness, challenges a forensic report, or cross-examines a lying witness, they are not just defending one person. They are defending the principle that no government, no matter how powerful, can take away a person's freedom without meeting the highest standard of proof. They are defending all of us. So let's bring this all the way home. Defense evidence is the shield of the innocent and the test of the guilty. It is the reason we have trials instead of simply accepting accusations as truth. It is the reason we have lawyers, courtrooms, rules of evidence, expert witnesses, and the right to be heard. Whether you are a law student, a practicing attorney, someone facing a legal situation, or simply a person who cares about justice, understanding defense evidence means understanding the difference between a system that serves truth and a system that merely serves power. The next time you watch a criminal trial, listen carefully, not just to what the prosecution says, but to what the defense presents. Watch how a skilled defense lawyer dismantles an argument with a single document, how a defense expert reframes an entire narrative, how an alibi witness changes the energy in a courtroom in an instant. Because in that moment, you are watching evidence do what it was always meant to do, not just convict the guilty, but protect the innocent. And that, more than anything else, is what justice truly looks like. Thank you for watching. If this video gave you clarity, gave you knowledge, or gave you something to think about, share it, save it, and come back for more. Because the law is not just for lawyers. The law is for all of us.